First of all, I'm very happy to be back here for the third time to the World Litigation Forum. So thank you for having me here. And I'm very happy also to see some colleagues that I saw previously and to meet new colleagues. I think I'm really honored to be with my two colleagues today because I think we're going to cover different part of this interesting topic of ethic issues. And I think will be very useful if we can also to have a more discussion rather than a simple presentation. So from my standpoint, you feel free to interrupt me anytime you wish to ask question or just to comment. I'm very happy to have a conversation if we're able to do so. It's true, it's very difficult to decide where to start with such a huge topic, and when I was thinking about my presentation, I decided to start with a little bit of a provocative title. Is there a common ground? And of course, the answer could be very simple. No, if we want to be blind, no, there is no common ground, or yes, sure, there must be some common ground. We are here to go a little bit into, the details and see what, first of all, what is the global overview? And, when we start talking about ethical issues, what do we look at? Are we looking at how we behave as lawyers? Are we looking at the difference in cultural? For example, I gave my previous presentation in the World Litigation Forum about cultural differences, and it was fun when I heard Mark talking about that. I think there were a lot of similarities on what we discussed last time. And it's true, we could spend all day talking about that type of difference. But I would like to, first of all, start and see what do we consider ethical issues and what has been actually the legislation on that, if there is one. What can we call one legislation on that? Well, first of all, we know that ethics is something that has been more and more considered in different jurisdictions by different bodies, different institutions. And from different perspective, we hear a lot the word ethics. We need to be more ethical. We or companies. I used to work a lot as an in-house counsel, and I remember one of the things that was common in all the company I worked for was we are an ethical company. So what is an ethical company actually? How we consider ourselves ethics, more ethics, what's the bench? And it's very difficult because, again, there is not one set of rules that we can say, okay, now that we have done our research, we can say this is correct, this is ethical, this is not. It very depends on what are we talking about exactly, where are we, because we also know that jurisdiction can make a difference on this topic. And we should also think about what are we talking about, thinking about the legal framework. So are we talking just about corruption? Because that's the first thing that a lot of time comes to our minds. Ethics, so corruption is definitely something that is not ethics. So are we covering everything by simply say, do we have any anti-corruption law? Well, I think it's not such a clear cut, so probably the answer is no, but it's my, let's say, first point, start to see where do we stand from a global overview in terms of anti-corruption policies. And what I would like to do then, after we go through briefly an overview of three, of course, I couldn't talk about all the national laws about corruption, but I decided just to pick three. And then I would like then to see which are some differences, similarities, but also which are the challenges for us, both from an internal counsel perspective and from an external counsel perspective. So if we take a look globally about the ethical issues that we face, again, we see there are many, but we also see that there are a lot of pieces of legislation. We can think about the conventions. There are many conventions on anti-corruption, just to name one, because normally it's the first word you hear, and then you recognize, okay, we have an ethical issue. If we solve the anti-corruption, probably we are at a good point. It's true, it's not the only topic, but it's definitely probably one of the most important, because we know that it has been there probably forever from ancient Roman in different ways, and has been dealt differently in different part of the world. So as we said, different conventions, we can go back, it's not really a new topic, but it's becoming more and more important. And together with the different conventions, the UN, the EU, another global convention, we have the national piece of legislation. And when we talk about national piece of legislation, we definitely think about the FCPA, we definitely think about the UK Bribery Act. Probably not everybody of you know the Italian law 23301, because if you're not exposed to Italian law, you may not know it. But there are other countries, German piece of legislation, Canadian piece of legislation. In Africa, we have, after the African Convention, we have a lot of countries that have passed their own regulation. So can we say that they have all the same basis, and knowing one piece of legislation, we should be fine with everything that happened? Because pretty much they should all go with the same goal: avoid corruption, prepare companies to be more ethical. Well, the answer could be, well, yes, there must be something in common. There is, but it's also true that we can see a lot of difference even when we take a look simply at the wording used by the different piece of legislation. And the conventions that were at the beginning and that started this process of passing national legislation were supposed to give some common framework. And therefore, a lot of people thought, okay, when each country will pass their own national legislation, they will follow what has been indicated by EU in case of that, by UN in the other cases, or by the African Convention, and therefore there will be a lot of unified rules. But it is not really like that in reality and in practicalities. And this is also why, when I used to work, especially my last job as responsible for compliance in the EMEA, when I used to receive the request about compliance with a certain piece of legislation of a country that was not familiar to me, and my colleagues were asking me, can we just simply say, yes, we're compliant, because we're compliant with everything, so must be fine. There's not going to be something wrong with that, right? Say, well, even if it's true, we should be compliant with everything, but we don't know exactly what's in there. Now, a lot of people think that if we are compliant, let's say with the most important, at least the oldest piece of legislation in this matter, the FCPA, we should be compliant with all. Well, if we take a close look, for example, and we compare the FCPA with the UK Bribery Act, we see that they're not the same. Do they have a lot of points in common? Yes, they do. The FCPA was passed in 77, so we're talking about pretty old piece of legislation in this topic. And of course, during the recent year, there has been some modification with the SOX in 2002, definitely some improvement, and there's been a lot of, let's say, different engagement of the court in discussing what exactly meant, the FCPA from a real perspective. But if we take a look at the UK Bribery Act, that is definitely newer because it was passed in 2010 and became enforceable in 2011, we see that there's been common ground, but there are still a lot of difference. There are difference in what is considered corruption, who can be corrupted, in passive and active corruption, for example, facilitation payment, sorry?
Giving gifts.
Yeah, exactly.
That's,
Exactly. Exactly. That's a key point, and we're going to discuss also that. And I would love to hear, by the way, your experience, because I will try to give you a couple of my personal experience in working with different countries, so I would love to hear also that. But again, UK Bribery Act, for example, was trying to go a step further compared to FCPA, thinking about we don't want the gray area. We don't want the facilitation payment exemption that we have in the FCPA. It's not mentioned in the UK Bribery Act. So what do we do, for example, in this case? The penalties and the fines for committing one crime according to the FCPA and the UK Bribery Act are different. Double of the years in case of imprisonment, for example, for the UK Bribery Act. But we can go on and see a lot of other concepts that are different. For example, when is applicable? The FCPA, when is applicable? The UK Bribery Act. This is one of the key issue that we find in a lot of national jurisdiction as well. How do we have a catch-all provision? So the FCPA, for example, tries to narrow down the perspective by including all the issuers, and there are a lot of companies, even if not established in the States, but they are listed on the exchange stock market, so that's a very good provision. But the UK Bribery Act thought that this was not enough and therefore said, okay, if we want to cover everything, we need to have a couple of provisions that make sure that we cover who is a citizen of the UK, but also anything that happens inside the UK. And then there is also a different version of the linked person, the interested person, that in my view is very important, because a lot of time some companies think, okay, if we can exclude the application of one of these rules, we can start focusing on the other. So let's say we don't have anything there, we can think about all the rest. And this is not always working, especially because even if you don't have a presence in the UK, but somebody of your employees or anybody from your company is in the UK and bribes somebody, that's perfectly applicable according to the UK Bribery Act. So it's not that if you don't have a legal established company there in that country, you're safe, for example. And I just wanted to mention briefly the Italian, being myself an Italian lawyer, the Italian law 231/2001, because as I said, I don't think it's very known unless you have been exposed to this piece of legislation. But it's interesting because there are a lot of common grounds with the FCPA and the UK Bribery Act. The main difference is that the way in which this law has been created is basically to make a cross-reference with the criminal code, and therefore, I would say almost every year there are new criminal offense included in this piece of legislation. But what is also, one of the things that it's important to underline is that the companies, in order to be Italian companies, in order to be compliant with this piece of legislation, need to update their organization model constantly, and a review probably is not even enough every year. You should do it twice a year sometimes, and that's a burden for a company, definitely. And even in that case, you're not so sure that if something happened, you will be, let's say, not held liable for that. Another very interesting thing is that there is a mandatory provision for creating a supervisory organ. In Italian, it's called organo di vigilanza, that has been translated supervisory organ or any other variation of that. I've heard at least 3 or 4 of them. But anyway, this is something that it's not mandatory in the other 2 pieces of legislation. And that just gives you an idea of how different can be the interpretation. Even if you have created, again, it's mandatory, this body, the supervisory organ, can be considered not enough if this body is not made of people that are, let's say, not totally independent, but as independent as they can be. So I've seen companies, for example, that have created this body just because they were supposed to, but mainly on paper. So they decided to take, okay, you are the CEO, you are the CFO, you are, let's say, the general counsel, you're going to be part of the body, and we should be fine. And given the fact that I did also some consultancy work for some companies about that, I was like, guys, this is really a red flag. If something happens, and you will be, of course, questioned about all the procedure, the models and everything. The fact that you have created a body that was required by law is not sufficient. If you have put 3 people that were totally not independent because they were actually employees of the company. Just to give you an example on how it can be different, not only just a piece of legislation, but also the interpretation that you give to that. And therefore, we have, something similar. We have a lot of differences, but what do we do? How do we, juggle between all this, and especially what do we apply? Because especially if we work in multinational companies, are we supposed to know every single piece of legislation around the world? No, we of course we can't, and we also know that even in such an important matter like ethical issues, like anti-corruption, it's not possible to know it all. That's why I was telling to my colleague before, one day, in my last experience in Comscope, I remember I received a phone call from a colleague of mine say, Virginia, I have a very quick question for you. It's very simple. Can you please tell me if we're compliant with the legislation in Mauritius about ethical issues and anti-corruption? And I'm like, I'm sorry, but on the top of my mind, I don't recall to have ever been exposed to Mauritius regulations on that. And again, being responsible, like a lot of us, for different part of a extensive region like the EMEA, it's almost impossible to know everything. But what we know is that we need to make sure that we take a look and we see which are the provision that might be different from our, let's say, standard, because again, we think that FCPA and UK Bribery Act cover it all. So if we are okay with that, we're fine with everything. Sometimes we don't, but not because necessarily the local legislation of a certain country is, let's say, tougher on something, just because maybe like the Italian law I showed before may have a different provision that you may not even know, like the creation of a specific body. And if you say, yes, I'm compliant with that, and then you don't create a body, or you have no clue how to do that, you may end up in fines, even if you are compliant with a lot of other pieces of regulation and legislation. So one of the big challenges that I have faced, there probably two main challenges that I would like to share with you and see if you had similar experience. One was really understanding if we were compliant in all the countries that we were based in. Again, really not from a pure, general overview. Yes, we're compliant. We don't corrupt, so we're fine. But really, practically, from a practical standpoint, do we comply with everything that is foreseen in that specific country? And a lot of time you can do this type of analysis, a specific analysis, only when you have either the issue or somebody's asking you to demonstrate that you are, because maybe you're subscribing a big contract and your counterpart won't prove of that. And the second challenge, in my view, is also making sure that the employees, when you go and make training, you provide training for them, make sure that the employees understand what ethic issues are and what is the standard of the company, that a lot of time is not the standard of the country, is not the standard of the person who's speaking, is not the standard of the person who's listening, but it's something else. Because the issue is that what can be considered, and we all know that, but sometimes in reality we face it more often than we think. What we think is okay, is allowed, is fine, is acceptable in a certain jurisdiction may totally be not acceptable in another one. And it happened to me during some trainings when I was talking about certain approaches, for example, on confidentialities and, what you should say, what you shouldn't say. I remember somebody saying, well, of course, I would never reveal a secret to my counterpart. But if I am having dinner with somebody, I don't really think who can listen, so I just talk. If we are talking about a commercial sales or something, it's not something that I ask myself, is anybody listening? I just talk because I don't think somebody should listen. And of course, that is something that goes a little bit beyond what is allowed and what's not, because, when I remember doing this training, say, if you are talking with your counterpart at dinner in a restaurant and you start talking about things that may be normal into a normal conversation with your counterpart, we're not talking about secrets, but something that is related to the company, and you don't even consider that you have other people that can hear and can listen to what you say, you might be actually infringing something if according to what you're saying, then other things happen. And some people thought that this was not actually their issue. They're like, no, but I don't have to think about who's around me. So what we may think, especially from a legal perspective, that it's common sense, is not really always, either because we're talking about salespeople or other people. I don't mean to offend anybody. We should be all lawyers, but I mean, I don't mean to offend any salespeople. I always joke about the fact that we are like, like opponents, but we have to work together. So they may have a different, value of what should be done or not. And this can be also based on jurisdiction. I remember once I was, again, giving a training, and somebody told me, I don't see why, if I am in Spain, I should comply with the UK Bribery Act. I don't care. I'm a Spanish citizen, and I am not concerned about either the UK Bribery Act or the FCPA. This is, of course, one of the first things that especially this happened to me a lot after takeovers, where small companies became, part of bigger group, and people were not always, and I'm talking about Spain, but it happened in other countries. I don't want to pick at Spain. It happened to me in Italy, in France, in Belgium, and many other situations, especially when a small company became a big part of a group. So, and a lot of time people don't really see their impact. So what I normally do is, okay, this is the situation. If you, who are in Spain, in Belgium, in France, no matter where you are, do this, this, and that, it's not only your responsibility, but something may happen also to your boss who stays in Cincinnati, in the States, for example. And sometimes people told me, no, this cannot happen. Yes, can happen, and let's see why it can happen. And therefore, I notice, again, especially during some trainings, that the level of awareness of people were not always so equal and so high to understand that really the action of one person in one country cannot be just the consequence of what is done. So in case I've done something wrong, yeah, go get me, we'll see. No, it's actually, it can be something very burdensome for the company. It can be something that has a lot of consequence for a company. So when I thought about possible challenges, this was something that really came into my mind. In my view, for us, it's a very difficult job to explain, but to really make sure that people understand that it's not just about a piece of paper. Okay, I need to comply with this. Where do I have to sign? Or, okay, I need to take a training. I'll take a training. No. It's really something you need to understand. And one thing I always say, if you don't understand, if it's something that for you doesn't make sense, come and talk to me. Let's have a conversation, a deeper conversation, because it's important that we really try to overcome all the difference and try to find the famous common ground that we were talking before, and that in my view is still not there yet. And one comment about common sense. I remember during a training somebody says, what you're saying is so obvious that we should just apply common sense. So I say, okay, probably common sense help, true, but are we sure that common sense, or what we consider common sense, is equal for me, for you, for them, for her, and so one day I decided to try something. One of the training that I was supposed to give was in person, and I decided during the training to show a video that was part of another training, an online training, and I said, honestly, what would you answer in this question, for example? And the answer, was this type of training are, in my view, sometimes so, black and white that it's very difficult to get it wrong. Like, okay, I give you money, you do this for me. Can I do it? Yes, no. No, okay, that's pretty easy. But then I decided to change it. I showed a video and then change the surrounding, the subject, and go a little bit deeper and ask a question that were like something that was not really so obvious and was more like, okay, in this case, probably for somebody was like a borderline question. So they start saying, like, for example, the example that I made about the table, about the confidential part, I made 3-4 examples of this, and they were like, in this case, I would actually, I mean, I don't think I will do something wrong if I do this, this, and that. So I said, okay, I like your point. Tell me, what do you think, when is the boundaries there? In which situation you would think to do something wrong? And in more than one cases, really, people didn't have the perception of what would have happened in that case and who was going to be the body to judge in case really something happened. And the body to judge, for example, in case of a breach of a UK Bribery Act or FCPA, was not the local judge of whatever country that could say, you know, I go there, I just explain, sorry, I didn't know, actually I was thinking differently, that's, you know, that's all. Like some people told me, it's okay, I mean, if it happens, I will just go there and explain, and they know the company has nothing to do with this. It's much more than that, but it's something that, especially in certain situations, it's not so clear and it's not so understood at the real level. So I think we have a very important job in, and when I say we, sometimes I still talk as an in-house counsel, but it's true for both of us, in-house counsel and external counsel. Don't take for granted, and also when people don't ask questions, you provide training maybe, and people say, yeah, I know, it's common sense. It's not always common sense because, again, common sense, especially in certain things and with so many different pieces of legislation, cannot be actually the same. So in my view, all the challenges that are there, beside the fact that we don't live in an harmonized world where one piece of legislation fits all, but also we deal with people that are the most powerful resource of a company, in my view, and therefore, if the people don't understand that we're not talking just about piece of paper, and therefore, you know, sign off, that's okay, I got it, did my homework, everything is fine, but we're talking really about something that can have an impact, and they need to understand what is the impact and what would be considered as, let's say, proof in case something really happens. In my view, until we don't do that, we may still face issues. And I don't think that only passing a new piece of legislation or refining the previous piece of legislation can help, as I don't think that just assigning a new policy for a company can be the solution, but really go a step further and in my view, a little bit deeper. So that, in my view, is really what we should do. Let's go further respect on just having, let's say, you know, our homework done with everything well specified on paper, but let's do the step forward. And I think from my experience that trainings are a moment in which we really have the feeling of what our colleague, in case we're in-house counsel, or our client, in case we're external counsel, think what they have understood and what can be done. So that's my point of view, and I don't know if you have a question or anything to share. We'll be happy to give you the floor. Yeah.
Yeah, I've been privileged. Yeah, I was privileged a few years ago to be part of a training of a client of mine back home, and it's interesting, this phrase, oh, it's commonsensical, why don't you, I mean, and what was the scenario? The in-house GC, the General Counsel, had put forward an argument that one of the policies of the company was that you don't receive gifts of a particular value, and reminded staff that on occasion they send out emails to clients, don't give a bag of rice, for example, don't give and somebody behind now raised the question, well, what if the Rolex watch I gave was fake and wasn't of the value, but it's a Rolex as far as I'm concerned?
Right.
And it was an interesting argument because the fellow said, well, I want to buy this particular customer client a gift for the services that they've been rendering to our company, but I don't have the funds to buy an original piece. But I see something they're hawking and I want to buy it, and now ethics committee may just come at me and say I bought a Rolex without knowing that it wasn't an original, probably a lot less, and in terms of value. And my concern at the time was, if a crime is a crime, regardless of the amount that is stolen, for example, why should the value of such an item
be considered?
Exactly. I mean, if there's a rule that says don't buy gifts, then don't just buy gifts. And I mean, so just to share that insight.
Well, I think it's very interesting because what I've seen in many companies now is that they have a policy where they simply say no gifts, no matter what. €1, 10,000 euros, for us is the same. And honestly, when I was in house counsel, I was sharing this with my colleagues that they were like, oh, come on, Virginia, we cannot do business like that. And I say, why? I mean, if we all have the same rules, you know that you are given a gift not because you want something in exchange. It's just to, show your nice gratitude for being a loyal, customer. Why don't you simply, do something that has something to do with the company? Like, for example, you give something that has no really monetary value, no value, and they just want to say thank you, or just a card, and you write whatever you want, zero value, but a lot of appreciation. If that's the purpose, you don't need anything valuable. And in my view, that's a really good point. Where do we draw the line? And we know there are a lot of ideas. We draw the line by looking at the value, market value compared to jurisdiction, and we can do all of that. In my view, would be much better just simply say, no, we don't do it, and it would be great if all the companies would do that. So there is no, offense if that company does it, the other company doesn't do that. And in going to the example of the Rolex, in that case, well, that was a clear case of where I want to show off something, but I don't have, or I don't want to spend the money for doing that. So I find something in between. I would definitely say no if I have to advise that company. But I would say no to even, less valuable things, because again, if we know that we don't want to, use it as a sort of, try to find the way to get into your favor or something like that, we don't need to do anything. So we just need to show our appreciation again by sending a nice card saying thank you, appreciate your valuable, customer experience. And by the way, this is a €1 chain with the logo of my, company, just to remind you when you get your card that you work with us. Something like that. But again, I will not start doing this bargaining thing. Okay, 10, 15, 20, 200, because when we have to do with a lot of jurisdiction, 200 in one country can be very different from 200 in another country. That's my view. I don't know if anybody wants to say something about this or any other comment.